spouse and children, just children, grandchildren, grandparents, siblings. I mean, there's a progression. And then if we're really left with no one, then Governor Cuomo gets his hands on the money.
Hey everybody, it's Dan Ratkowicz, and this is episode 12 of the Helping Hands podcast. I wanted to change up the format a little bit with this show because there are the last 4 months or so, I've been having conversations with people, and this topic has been coming up a lot, either from customers or from people that have been DMing me or people in my friends and family about these topics. And I think it'll help a lot of people out. What I've found is a lot of people either have a lot of misinformation or they think that they know what they're talking about, but they're a little bit off, or they are afraid to ask. And I figured this will be a good opportunity that we can put out a lot of good information and get it out there. So Jordan, I want you to introduce yourself a little bit, like 2 minutes of who you are, okay, and what you do.
Okay. My name is Jordan Linn. I'm a trust and estates attorney. I've been practicing for almost 20 years. I'm a partner at a firm called Chaves, Perlowitz, Luftig. We're located both in Manhattan and in Jericho on Long Island. We're just about to open up an office in Jericho.
Nice.
And so I'm a Long Island native. I've been practicing on Long Island for almost my entire career. When I say Long Island native, I mean I actually grew up in Brooklyn, but eventually migrated out here after a mandatory quarantine in Queens for a little while. You know, you're not allowed to go directly from Brooklyn to Long Island.
What part of Brooklyn?
Like Sheepshead Bay, Brighton Beach, Coney Island area.
Gotcha.
I went to Lincoln High School. Shout out to Lincoln High School. And yeah, so I've been, ever since graduating law school, I've been practicing in the trust and estates area. So people come to me all the time with the types of questions that you're referencing. What do I do? How do I handle my estate planning? What happens when one of my loved ones dies? What do I do? And that's what I do. Right.
And some people may be confused. Hang in there, because there's good information in here of what exactly Jordan does. And I kind of want to just jump right into this scenario. This fictional family, Rick and Sally.
Okay.
Let's say, they have 2 kids. Mm-hmm. They go to Costco for a trip. They leave the kids at home, mm-hmm, and they're in a car crash and they pass away.
Right.
Sorry to start off with this terrible story, wow, but it's out there, and these things do happen. And I think in both the business that we're in, we face things like this all the time where we want to protect this.
Yeah.
So what would Rick and Sally, mom and dad, want to have in place to make this horrible situation for their kids a little bit better, and not just complete chaos?
Right. And so basically what we're asking is what's the foundation? What's the baseline estate planning documents that everyone needs? And I guess the misconception is, I don't have a lot of assets, therefore doesn't really matter. I don't need to do anything. Not really true. And they're just a basic baseline of documents that I think everybody, that especially if they have kids, needs. First off, a will, a last will and testament. The last will and testament disposes of your property after you're gone. So you may say, I don't have much property, or the property that I have already has a beneficiary designation on it. It's owned jointly with my wife. It's a life insurance policy that names a beneficiary on it. So I don't really need a will. Well, number one, if both Rick and Sally die in that car accident, both joint owners of that property are now gone. So where does that property go? That property doesn't know where it goes automatically upon death. The last will and testament will determine that. Okay. And we'll get into what happens if you don't have a will. But really the part that's significant is they don't have a guardian appointed for their child. They have minor children at home while they're away at Costco, and there's no one in particular appointed to gain custody of those children if something happens to Rick and Sally. So very important to do a will, if for nothing else, to appoint a guardian. The other documents that I think everyone needs is a power of attorney If you become incapacitated, who has the authority to step forward and deal with your assets on your behalf? That's while you're still alive. So if you became incapacitated, who can sign tax returns on your behalf? Who can deal with your assets, pay your bills, et cetera?
So they didn't. So let's say in that same scenario, they didn't pass away, but they're in the hospital.
Yeah,
they can't do anything. They can't make decisions. They can't pay the rent. They can't.
Right. Nobody has access to their assets.
Right.
Nobody can pay the bills so that the children can continue to live in the residence. We've got a big mess on our hands. And the only way to work our way out of that mess in the absence of a power of attorney is something called a guardianship proceeding, which is a court proceeding, can be very messy and expensive, something that you don't want to be. You don't want to be in guardianship court if you can avoid it. Another document that everyone needs is a healthcare proxy. And you'll sometimes see those if you go into the hospital for a procedure, they'll ask you to sign a healthcare proxy. Very similar thing. And the idea there is to just appoint someone to make healthcare decisions for you if you can't make those decisions for yourself any longer, or just temporarily. So picture, people like to imagine the worst case scenario, pull the plug or not pull the plug. And that's not really all that a healthcare proxy does. It also determines, let's say you're just in surgery, you're under anesthesia, and the doctor comes upon something that they didn't anticipate, and they go out to the waiting room and they say to your family, should we do this additional procedure or shouldn't we? Who's to make that decision? You're unconscious. You can't make that decision. So right. Who's your healthcare agent? Who's the person that can decide whether a medication should be administered or a procedure should be given if you're not able to communicate your wishes for yourself? So you need to appoint someone as your healthcare agent. And then lastly, the living will. And that's the document everyone thinks about where they say it's like, I don't want to be kept alive by artificial means if things are really hopeless. That's the living will. It kind of expresses those wishes so that your healthcare agent has the authority to tell the doctors when it's time to stop. And we're keeping it really morbid, so I just figured I'd take us there. But, that I think that's a long answer to your short question.
Okay, no, and that's very good. And I think a lot of the misconception is a lot of people think that it's when grandma needs it because she's getting older and she's going into the hospital for something. But in those situations, anybody can get into a car accident. Yeah. Especially if you've got people that you're responsible for, that people count on you. Yeah. These are ideal things to set up.
Yeah, and as a parent of young children like you are, those situations stick out to me in my mind. When I have to deal with clients where it's young people with young children, and there are these situations that come up, it really resonates with me, really sticks with me, as I think it would anyone. That really the most traumatic stuff. When you're dealing with families with young children, and it's really that made that much worse when they haven't planned adequately.
Right. Along the lines with trusts, my wife Christine and I run an insurance and financial services business, and a lot of our clients will come to us making changes on their homeowner's policy because they're adding a trust onto the policy. Can you tell everybody out there what those trusts would be for, and when people should start thinking about?
Yeah, and we were saying just before we started the podcast that I think a lot of what we do is kind of similar, right? Because really we've got these clients that are spending their lives trying to accumulate assets. They're trying to live that American dream, right? They're accumulating a home, they're accumulating a retirement account, they've got life insurance policy. And it's the time that they're spending now with us to try to set up things correctly so that those things are protected and that they end up in the hands of the right people if things don't go according to plan or when they eventually pass on. So part of doing that correct planning is sometimes implementing trusts. And the two main types of trusts generally, and the two main types of trusts that you're seeing where your clients are looking to transfer their property, their real property into these trusts, are revocable trusts and irrevocable trusts.
Okay.
A revocable trust is really just like a wrapper that you place around your assets. If you have a life insurance policy, as I mentioned, it usually has a beneficiary. It knows where it goes when you pass away. So there's no need to bring it to court in order to figure out who the beneficiary of that policy is. It's right there on the face of the policy. You produce a death certificate and the insurance policy will pay out. Same thing with a retirement account that has a beneficiary designation. But a piece of real property and other assets don't have a beneficiary on them. So we've got this issue of having to go to court to probate a will in order to give that will legal effect so that somebody can take possession of the house and sell it or mortgage it or transfer it or do what they need to do. A revocable trust is this vessel, this like a briefcase that a client will carry around with them during their lifetime. And what they'll do is they'll deposit their assets like their home, do a deed, transferring ownership of the home from the client to their revocable trust. Once we've put the house into the trust or any other assets, the trust already says right on its face where that property goes when the person passes away. So there's no need to go to probate in order to get that property transferred to the next beneficiary. It just passes automatically.
Probate is is that a court case? That's
So that's a common question. What is probate and why is it a dirty word? Because people, oh no, probate. And probate can be a terrible pain in the neck. A will means nothing until the court gives it legal effect. Okay. So I'll sit down and sign a will with my client, and they'll give instructions for what they want to see happen to their assets when they're gone. And then it'll sit in a drawer for 25 years. And then when they pass away, somebody wants to give that will legal effect. But the will means nothing until the surrogate's court in the county where they live takes that will and says, yes, this is the last will and testament of Sally, right? So that process of getting the court to accept that will and carry out its instructions is called probate. And where you have a family where everyone is cooperative, nobody is looking to contest anything, everyone's being treated equally, everyone's happy and in agreement as to who should serve as executor, et cetera, then probate doesn't necessarily have to be a dirty word. But where you have issues, and there are a lot of different things that can trigger issues in a probate proceeding, you're better off having this revocable trust. So there are a lot of reasons why we do them, but when you see a client saying, I'm putting my home in a revocable trust, it's really usually to make the administration of their estate after they're gone much easier. They're basically preloading this trust with their assets so that when they're gone, there's no probate required and the administration of their estate is very easy. The other type of trust, which you mentioned, that you'll see clients transferring their property into, is an irrevocable trust. And those trusts that you're seeing are usually Medicaid driven. So meaning that a client doesn't want their home counted as an available asset in the event that they become sick and need nursing home care for an extended period of time. They don't want the house sold and the proceeds used on the cost of their care. They would rather that house and any other assets that they can protect pass to their children and further descendants without being consumed by the cost of their care. So by transferring the property into a Medicaid qualifying irrevocable trust, you trigger this 5-year look back period where if you were to need a nursing home within that period of time, you would not be eligible to receive Medicaid during that 5-year look back. But once you get past that 5 years, you can successfully have transferred the house out of your name for Medicaid purposes and be able to qualify for Medicaid while still being able to occupy the house. Right. You're just giving away the equity. So you reserve what we call a life estate in the house, give the rest to a irrevocable trust, and try to get the best of both worlds.
When is the best time for somebody to start looking at this process? Because with the 5-year look back, where somebody if somebody gets sick, and all of a sudden now this is real, that's usually when people probably start scrambling and calling you, and now it's like, well, you're probably limited a little bit in what you can do if you didn't put the proper planning in beforehand.
Yeah, you really need to get that 5-year look back clock running as early as possible. But you also don't want to let the estate planning tail wag the dog. So if a client doesn't know where they're going to want to live in the next 5 years. Well, we might be moving to Florida. Well, you're making it more difficult if you start transferring your property into an irrevocable trust now, because now you've got to deal with your children, I guess, as trustee. and they have to be the ones to sell the property. And there are just a lot of issues related to that. So it's got to be the right fit. People have to be at the right place in their life where they're willing to lock themselves in, transfer that property into the irrevocable trust, wait out the 5-year look back period, and qualify for Medicaid. So I guess the answer is do it at least 5 years before you need a nursing home, which unfortunately you don't always know when that's going to be.
Right.
I always say to my clients, people really fall into 3 categories. There are people with very little in assets where they're going to qualify for Medicaid, no problem. They don't have all that much to protect anyway. Then you've got the clients that have, $20 million, and the cost of a nursing home is not going to really be a significant problem. They're able to self-fund if they need to go into a nursing home for an extended period of time. It'll be paid for. And then there's everyone else in the middle. And those people really need to consider either engaging in some type of estate planning to at least protect some of their assets, or look into a long-term care insurance policy, which I don't know if you handle those.
They on the financial services side, they handle long-term care policies, and important if somebody gets hurt and they can't they need nursing home, they need assistance.
And those policies, it's gotten more difficult. I think some insurance companies lost their shirts on those, so the premiums have gone up a little bit. But there are all different types of policies out there for long-term care. It's something that those clients in the middle space that don't really want to give up control over their assets, long-term care insurance is something that I always recommend they look into.
Right. If you're just joining us, this is the Helping Hands podcast. We're talking with Jordan Linn. He's a trust and estates attorney. Jordan, so what happens when somebody doesn't take your advice? Right. They don't set up a will. They kind of bury their head in the sand and say, "Well, it'll be all right." Right. And I guess one of the misconceptions that I've heard from people the last couple of months, well, if I pass away, well, my kids will just get everything.
Right.
Like, well, how old are your kids?
Right.
Well, 13.
Yeah.
No, yeah. And that it doesn't happen. So what in that situation? What happens? Yeah. To the house, to any bank.
So if you don't have a will, New York has a will for you. It's called laws of intestacy under New York state law, and it really provides what the state considers to be a logical plan for what should happen to your assets if you die without a will, and who should be the executor of your estate if you die without a will. It doesn't really cover the guardianship issue, which means you could have a war of grandparents or something. If I forgot the husband's name, I remember Rick. Sally. Rick and Sally pass away. Rick's parents and Sally's parents
they don't get along.
In court,
they don't get along.
Right, we knew that.
Yeah.
So there's these laws of intestacy are not always logical. When New York State thought they were logical, but they're not always what Rick and Sally would have wanted. For example, if something happens to just Rick, right? Rick and Sally don't have a will. They don't believe in estate planning in any way. So if Rick passes away, he would assume all of these assets that were in his name, Sally will get them, and she'll be able to use those assets and put the kids through school and do everything that she needs to do with those assets. And it'll work out that way. New York State, the laws of intestacy provide that if Rick dies without a will and he's got Sally and he's got some children, the property actually gets split between Sally and the children right at Rick's death. So you've got money in a trust in the name of a 13-year-old that Sally really can't readily get to because that's what New York State law would provide.
Wow.
So yeah, I mean, it doesn't always work out the right way, but basically people sometimes are into the misconception, if I don't have a will, everything's going to go to New York State. Well, that doesn't really happen either. It's a little bit more logical than that. It would go to spouse and children, just children, grandchildren, grandparents, siblings. I mean, there's a progression. And then if we're really left with no one, then Governor Cuomo gets his hands on them. So, yeah.
All right, and with some of the other events, like what are you may have come across some stories in your career of like just some like fights, between and one of the things, I mean, I actually didn't think that if it was husband and wife and the husband passes away, that it wouldn't just all automatically go to the wife.
Well, I mean, there's a lot of nightmare scenarios, and obviously estate litigation, which I don't do estate litigation. I'm more of a, I like my clients to be happy when they leave, or at least feel like they came in to get something done. It got done. They can take those documents, put it in a drawer, and they're not mad at me when they're finished. Estate litigation is a very fertile area for attorneys because the litigants aren't always logical, right? Yeah. They're emotional about this. Sure. Somebody passed away and they feel they weren't treated fairly in one way or another, or their sibling did something that they don't like, and they'll spend $100,000 fighting over $5,000. So litigation is really a bad place to be. But when I was talking about intestacy, it made me think of a situation that I see all the time, where clients try to do what I call do-it-yourself estate planning. They say, well, I don't want to deal with wills, and I don't want to deal with lawyers, and I don't want to deal with all of this confusion and trusts. I don't like trusts. So I'm just going to take my house and I'm going to give it to my kids now, or I'm going to put my kid's name on the house now. Not a great idea. And it actually can cost the family a lot of money. And I'll tell you why. If I have a house, and I see this all the time, I have clients that come in and they have a house that's worth $750,000, and they've been living there for 50 years, and they decide to give it to their kids, but they put it in their kids' names now, so it doesn't have to go through their estate, and they think they've done. First of all, you're supposed to file the gift tax return when you did that, but people don't always pay attention to that. But what they've done is, then I say to them, okay, you think your house is worth $750,000. How much did you pay for it? And they say, I paid $23,000 back in 1962. And I say, okay, that's good. So your basis in the house for income tax purposes is $23,000. Now it's worth $750,000. So if your kids have this house now and they go to sell it, they've got your basis in the property because you gave it to them. So they're going to have to recognize a capital gain on about $725,000. So they're going to pay a lot in capital gains tax. If you were to have held that property or given it to them but reserved the life estate in that property, which is what I would have told you to do, and you held that until your death, when they inherited that house, they would receive a step up in basis to the date of death value of the house, completely erasing that capital gain. We'd have zero capital gain. But now, because you decided to do it yourself estate planning, you basically have $150,000 worth of capital gains tax to pay.
Right.
Doesn't really make a lot of sense. So, there are a lot of nightmare scenarios like that where people have misinformation and end up putting themselves in a worse position because of the fear of dealing with this type of planning.
And I'm sure the cost and the time to set up the proper estate plan is a lot less than the $150,000 and all the headaches and the amount of money that you spend on Tylenol during that process.
Right. I mean, generally estate planning, the basic kind of estate planning that we're talking about, is done on a flat fee basis. So usually a client will come in to see me, I'll get a sense for what they need, and then I'll tell them what it'll cost. It's not
$150,000.
Right. It's nowhere near 100. Unfortunately, it's nowhere near $150,000. But if it turns to state litigation, I wish I was a litigator, because that's where the fees really begin to pile up.
And you don't want to do that. And I'm sure that so I guess because you probably don't see that too much because you're on the front end setting up the proper plan for people. But the headaches, and we hear it from clients all the time where, everybody's got that, the crazy aunt in the family that you'd imagine in a fight with that for your kids, or, fighting, crazy aunt, whoever, about, the custody of your kids, and she's dead set on doing this because of some other reason, or, it's so much better to set it up beforehand.
And you mentioned children, in most cases, people really don't want their children to get property outright. Either if they're young, obviously you don't want them to, minors are not going to take control of a few $1 million outright, or a few $100,000 outright. And so usually you want to set up trust for them, at least until a certain age. But now I find most people say, you know what, can we protect this money from creditors, because I don't really like my son's wife or I don't really like my wife's husband, or, I like them well enough, but if they get divorced, I really wouldn't want them to have any of this money if something happens to me. So we're able to accomplish that right in their wills to set things up so that their child will get their inheritance in an asset protected way, so that they don't, it's not that money is not in jeopardy in the event that they get divorced, or if they get sued in the future, they have a car accident where they're sued above their policy limits, or my child's an anesthesiologist. And, there's a lot of reasons why people want asset protection in today's litigious society. So, we're always faced with that as well.
One of, so when should people start looking at working on planning for their estate? Is it at when they get married? Is it when they have kids? Is it when they, the kids get a little older? Is there,
things get, as your situation gets more complex, planning can get more complex. And there's a lot of sophisticated planning that I'm not really talking about today, because it's really only affects ultra high net worth people, right? The federal estate tax exemption right now is $11.4 million per person. Married couple, $23 million of available exemption. So, when you hear politicians talk about the poor farmers and saving them from the estate tax, that's not really who they're talking about. They're talking about themselves. But so, there's a lot of planning work that I'll do for those high net worth clients to avoid estate taxes. But for other people, it's really just a matter of protecting what you have. And it's just as important that client that's worth $300,000, that's everything they have. It's just as important to them as someone who's worth $5 million and their $5 million worth of assets. It's everything they have, and it's what they want to be able to pass on. So, certainly as soon as you have children or you own a piece of real property, you should have some type of basic estate planning in place, if not sooner. And then as I hope the situation gets really complicated. I hope, when I go through my clients' assets and I find out that they don't have $11.4 million, I say good news and bad news, right? I wish you did, because you would have more sophisticated planning, and that would be good. But, now it's a simple plan. So we can keep things relatively simple and cost efficient. It's like going to the dentist, right? You have to do it, but once you've done it, it feels good to get that burden off your, the weight off your mind.
Right. But you do have to revisit it, the dentist.
Yeah. Right.
So when your situation changes, when
your situation changes, you'll have a good sense for what you did and what those documents provide. And certainly if your feelings change, or the family situation drastically changes, or the laws drastically change. And usually, you'll hear about that, or sometimes I'll send out a bulletin to my clients just to say, hey, by the way, the estate tax exemption is, it used to be $675,000. Now it's $11.4 million. Things have changed. You might want to revisit your estate plan. But usually it's, every 3 to 5 years, just pick up the phone and give your estate planning attorney a call and just say, has anything changed where I need to update my documents? Okay, no, and that's it.
And that's
not, again, not a big involved problem. It's just something you have to maintain.
Right. And hopefully, you take Jordan's advice and check this stuff out. We'll put Jordan's contact information in the links if you'd like to get in touch with him and his firm. And it's just one of those things, we got to, be the big boys and girls and look at these things and plan these things and make sure it's set up. We're not the most, the insurance guy, the attorney, and you're talking about a dentist now on top of it.
Right.
I mean,
the accountant.
Right. Let's bring all the
people that we deal with are not, not the fun people in the room, but we are necessary evil, I guess.
Right. But we have a good time too. So
yeah.
But thank you so much. I think you brought a lot of great information. Is there anything else that we didn't touch upon that you think that I think on a big scale? I mean, there's a million things that we can talk about, and there's case by case things too.
I mean, I guess something just came to mind. I'll throw it out there.
Sure.
Just in case it's of interest. When I mentioned the federal estate tax exemption, what I didn't mention is the fact that New York State still has an estate tax as well. Most states don't. New York does, which is why you see actually a lot of people moving out of New York State if they can, in order to avoid not only the estate tax, but the income tax burdens that are pretty high here in our state. What's really unfair actually about New York's estate tax, it's a $5.7 million exemption, so it affects more people, not everybody. But you come to think about people who live on Long Island. If you own a valuable home, you've got a retirement account, you've got a life insurance policy with a death benefit that you hold that's a couple $1 million. If you add it all together, all of a sudden now you've got a taxable estate. And the problem with that tax is that although it's a $5.7 million exemption, if you exceed that amount by 5% or more, the entire exemption goes away and you're basically paying tax on $1. Wow. So you could find yourself with a significant New York estate tax just for having crossed over basically the $6 million mark in total assets.
Right. And your total assets also include property that you own too, correct?
So the value of your, and even if you put it in a revocable trust, by the way, still part of your estate. It's where you start with the irrevocable trusts that you're getting it out. So yeah, real estate, retirement accounts, bank accounts, non-qualified brokerage accounts, life insurance policies, add it all together.
But that's something like I'm thinking about our clients that are in real estate, that they own shopping centers, they own apartment buildings. Those are, those they have, when you add those up, they may not have $5 million, in the bank, but they have more than $5 million worth of property. And I think that'll. So
those clients really need a little bit of a higher level of estate planning. Otherwise, there's going to be a big surprise when they pass away that their family is going to have to pay a significant estate tax to New York State, which is avoidable with just some additional, less basic but still basic estate planning. So definitely something to keep an eye on as well.
Right. Actually, I was having a conversation with one of our financial specialists, and he was talking about Joe Robbie. Mm-hmm. And he owned the Dolphins, and he passed away. And the family had to sell the Dolphins organization because they had such a huge tax burden to come up with cash at that time.
And again, that to me, that's an avoidable situation, especially a family of that level of means, that they should have to do that. Because normally, when I see a situation like that, I say, life insurance.
Right.
You buy life insurance with a high death benefit. You place it in an insurance trust. The proceeds of that insurance are now excluded from the person's estate. So if they anticipated a $20 million, $50 million estate tax, assuming his health was good enough to do it, he could have purchased life insurance with a death benefit that would have satisfied the estate tax, so they wouldn't have had to do that. Right. But I'm a Jet fan. I don't like the Dolphins, so I'm happy if there's any inconvenience to any Dolphin fans anywhere. So.
Perfect.
This doesn't go to Miami, does it?
Right. But perfect. Great information. Again, we'll put all the information in the links. Jordan, thank you so much for taking the time and giving us the information. I think we helped a lot of people. I think you gave a lot of people a lot of information that, like I said, that they either have misconceptions, they're confused, or they're too afraid to ask. And hopefully, now you know that it's not your fault. There's a lot of people out there that don't know about this stuff, and that's why you have experts like Jordan to go through these and make sure that you're properly protected. So thank you very much.
Thank you for inviting me. This was great.
I appreciate it. Have a great day.